Committee, can I just go through the protocol for the meeting? Only speak when invited to by the chair. If you wish to speak, please raise your hand and direct all communication via the chair. Will everyone please ensure that their mics are muted when they are not speaking, apart from the chair? If you have any technical difficulties, please use the chat function in Google Meet to alert the meeting. Once the application has been considered, any remaining parties will be asked to go out of the hearing. Please do so promptly so that councillors will have the opportunity to deliberate and make a decision. Each party will be notified of the decision within 5 working days. So if I can just go to the first item on the agenda, can we elect a chair, please? Oh.
Councillor Root, did you want to propose?
Yeah, sorry, I was just trying to fight with my microphone. Could I propose Councillor Bouvier, please?
Councillor Osman, would you like to second?
Yes, I agree with that. Seconded, yeah. Seconded.
Thank you, colleagues.
Thank you.
Okay, thank you very much. So moving on from the agenda, item 2, apologies for absence. We do have apologies.
Shall we have apologies from Councillor Peters?
Yeah, and I'm substituting for Councillor Peters. So do we have any declarations of interest? No.
No.
Councillor Ozan, I think
No.
be on camera, I believe. Is that right?
Yeah, 1 minute.
If you don't mind.
Yeah.
Thanks. Thank you. Then I can see if you. Okay, so no declarations of interest. I'll just very quickly run through who's present. Myself, Councillor Emma Clouvier, Councillor Ozan, also from London Fields Ward, and Councillor Root from Victoria Ward. Yeah, thanks. We have Rabia, who's our governance officer, David Tuitt from licensing, Robert Gardner from licensing, etc., Suba from licensing, and David Forbes speaking for the applicant. I mean, for the premises. Yep. Okay. Thank you. And Amanda North, who's our legal officer. Okay, that's all. And Mario, who's handling the IT. And if people have problems, do contact him through the chat. Thanks, everybody. That's all the people who should be here. The next item on the agenda is item 4, minutes of the previous meetings that are in the papers. We have 2, the 3rd of August and the 14th of August. And I believe, Councillor Root, you can...
Yes, I was on both of those committees and I'm happy with both of those sets of minutes.
Lovely, thanks very much. Okay, item 5 is the Licensing Committee hearing procedure. I'm just going to run through it very quickly. We've done the appointment of chair and introductions. The next thing that happened is the licensing officer, Suba, will outline the report. Then the applicant in support of their application and calling for a review will make their statement. And then I don't know if we have responsible authorities supporting that. We don't. So then it, oops, and we don't have other people here. And then we'll hear from the response from the premises license holder before we move into a discussion. At that point, any questions or points that people want to raise, they do so by putting up their hands. I can see you all, or putting up the Google hand, and questions through the chair, please, before closing remarks, if anybody needs to make any, and we'll then make our decision in closed session afterwards. Okay, I hope that procedure is clear for everybody. Assuming that it is, I will move on and ask Suba, please, the licensing officer, to outline the report for us.
Thank you, Chair. Licensing service are in receipt of an application from the licensing authority for the review of the premises license under Section 51 of the Licensing Act 2003 for the Eildor Acts 69 Hackney Road on the grounds of the prevention of crime and disorder, following numerous breaches of requirements under the Health Protection Coronavirus Regulation 2020 and continued unlicensed operation as a sex entertainment venue. We have received additional information from the premises license holder, which has been circulated. I have nothing else to add. Thank you, Chair.
Thank you very much. Okay, in that case, if anybody's got, excuse me, has anyone got any points of clarification that you want from either councillor, from Suba? No? Great. Okay, in that case, over to the applicant, Rob Gardner, please, from Licensing.
Yes, good evening, committee and chair. The committee will have read, as members will have read the statements which we've submitted to you, so you will know the details of what we observed on our visits on the 4th of July and the 9th of July earlier this year. I think it's worth it to say that during the epidemic, and the ongoing epidemic I should say of course, we visited a very large number of premises throughout the borough. And although some were found to be non-compliant, and indeed these were taken to task, there was none that were as bad as this particular venue. It was observing none of the actual requirements of the regulations as we saw it at the time. There were no notices, there was no QR code, there was no table service, no records were taken as we entered the premises, no one was wearing any masks, and indeed there was no signage to it. This list is all there for you to see. There were no controls basically on this in this particular premises. The premises were subsequently fined, and rightly so, £1,000 which they paid, and I believe Mr. Forbes has outlined that in his argument back to the committee. Committee will note that we visited twice over the space of 1 week. Towards the end of the period of restrictions, I would say that there was no evidence there that there had ever been any sort of controls really. Certainly there would be no posters left up, no, the staff didn't seem to be particularly concerned that people were standing and milling around within the actual venue. But there was basically no concern at all. And there was no evidence, I would say, that, or residual evidence of the controls had ever been put in place in the first place. But of course, we can't talk about that because, of course, we didn't visit prior to the 4th of July. The licensee has told us that he was in Bishop Stortford due to family issues. Bishop Stortford is 32 miles away, 55 minutes by car on a good day, I guess. And I have to say that during our and also there was extensive publicity up until that time, and virtually the channels were full of it. I think we'll all remember what was happening at that time, and that the press was absolutely full of as to when nightclubs would be open, as to when the restrictions would be relaxed for the entertainment industry. The airwaves were full of this information. To say that there was that the staff or people in the trade did not know is I think fanciful. Many businesses indeed might have been operating through some form of distance management arrangements, but there were none that we found that were so lacking in any basic controls or any sort of supervision. One would have hoped the licensee had left the premises with perhaps experienced staffing arrangements, but this did not appear to be the case on the evenings that we visited. The failure to apply the controls were wholesale and gross, especially as to what the committee will now, and especially as to what the committee I've submitted in the statements to what you've read, especially concerning the contact with performers upstairs. There was absolutely no distancing whatsoever. There was complete and utter sort of physical contact, quite opposed to the fact that this was not allowed under the sexual entertainment license that the premises currently has. Indeed, no sexual entertainment licenses was allowed to open at that time, but I will make the observations that although that was indeed the case, that they were operating one, they were not permitted to do so. However, they were operating one, or the premises where it was. And when you look at the actual nature of the performances that we received, there was no table or dais. I point to the standard conditions contained in the standard conditions issued in relation to a sexual entertainment license. The performers were not distanced in any way. There's supposed to be no physical contact, which was completely ignored. And it was just, it's just extraordinary. I've never had anything like, I've never seen anything like it. The committee, I mentioned in passing that I think I mentioned it because residents have, I think, have brought it up, and that is indeed the sort of the court case that was heard earlier this in 2019 in relation to fire controls, and Mr. Melody being found guilty of a technical offence, I think, on that issue, and I'm sure the other side will expand on this. But I just leave you with the court, with the judge, the judge's remarks, which reported in the press, which said that Mr. Melody appeared to have treated fire safety officers with a measure of disdain and possibly arrogance when they advised him to install a working fire alarm. And furthermore, the judge then said, the message must go out that the law is there to be observed, and for very good reason. The committee has heard from Mr. Melody previously. In May 2019, there was an assessment of whether he should be granted an SCV license. And the chair of the committee at that time, in May, this is in May 2019, Councillor Peter Snell said his final sort of remarks were, "I trust that these premises will be better managed in future." I put it to the committee that that's not the case. I would also point out, and no doubt your legal advisor will speak to you about this in the guidance, Section 182 guidance. It says that where reviews arise, this is section, I think, 11, somewhere in section 1128, something like that, where reviews arise and the licence authority determines that the crime prevention objective is being undermined, it is expected the revocation of the licence, even in the first instance, should be seriously considered. And that's what I ask you to do this evening. Thank you.
Thank you, Rob. Thank you. Okay, any points of clarification?
I've got a couple, if that's all right. The first is, Mr. Gardner, you mentioned that Bishop Stortford is 32 miles away or 35 miles away. I can't remember which. I just wondered, is that distance of any particular significance?
I just wanted to draw it to the committee that it wasn't a long way away.
Okay. The other thing I was going to say was, given the serious breaches that you're talking about here, there's nothing here from the police, and I'm sort of wondering why that might be.
I'm not sure why that's the case.
I'm just a bit surprised, really, given the number of breaches and the severity of them, that there's nothing here from the police.
Okay. Were there police doing visits at the same time?
They weren't doing the routine visits that we were doing. They have their own visit schedules. They did, in fact, accompany us. Well, two uniformed officers accompanied us to the venue when we returned to it after the experiences that we had on the 9th of July, to observe that we tried as we closed the premises down, because at that time we felt it was unsafe.
Okay. Thank you. Okay.
That was a voluntary closure, incidentally. We did not ask them to and they voluntarily closed at that point.
Okay. Anything else for clarification before we move on? Okay. In that case, we'll move over to David Forbes and hear from you for the premises.
Thank you very much. Can you hear me all right?
Yes, very well.
First of all, reference has been made to some written submissions that I put before the committee at its meeting last month. I take it, Chair, that you and your colleagues have had an opportunity to read those.
Yes.
Yes, excellent. Well, I don't want to repeat verbatim all the material that is there. There's a good deal of it, but obviously I continue to rely upon it. But I think first off, I would like to draw the committee's attention to the grounds upon which this application is made. And they are, on the paperwork, twofold. Firstly, what are referred to as breaches of the Health Protection Coronavirus Regulations 2020. And secondly, continued unlicensed operation as a sexual entertainment venue. Can I deal with the second ground first? Because I was at some pains to point out in my written submissions to you that that is simply not the case, because by operation of law, there was and still is an SEV license still in operation. Now, I understood from Mr. Gardner when he addressed the committee on the 16th of November that he now accepted that that was the case. So ground 2, unless it's still pursued by Mr. Gardner, is no longer before you, in which event we are only looking at ground 1, which is supposed breaches of the health protection coronavirus regulations. Well, now, I've taken the trouble to have a look at what those regulations are. And to be frank, they don't cover anything like what Mr. Gardner has said about it. The one thing that is clear is that they do require, or did require at that time, premises of this nature to insist upon customers restricting themselves to table service so far as the service and consumption of food and drink is concerned. Mr. Melody has accepted and has never disputed that the fact that his staff precipitately removed that restriction before they should have done, as a result of pretty much at the last minute the government having changed the date upon which the restrictions would be removed, he accepted that he should not have allowed that to happen. That was due to his temporary absence from the premises, and he regrets that. He's been penalised for it, and he's paid the penalty. But I'm afraid I can't find anything in the regulations which would prohibit the other things that Mr. Gardner has referred to. I can find nothing in the regulations which make it an actual legal requirement to take people's details on entry. It may be something that would be desirable, but it's not actually a breach of the regulations, so far as I can see, if you don't do it. If Mr. Gardner can point me to a regulation, then I shall be happy to change what I've said. But I don't believe there is any. Moreover, there is nothing in there that I can see about mask wearing. Maybe at one time there was, but it wasn't in July of this year. So far as the private dancers are concerned, pursuant to the SEV license, those may or may not be breaches of the sexual entertainment venue license, which was before the committee in November, but was not decided upon, and I note is not before the committee tonight. In any event, even if they were breaches of the terms of that license, that is not something which by itself would amount to a breach of the coronavirus regulations. And again, unless Mr. Gardner can point me to a regulation which covers it, because I can't find one. So, Madam Chair, what I would suggest is that the committee, in looking at this application, is confined to what is actually before you, and that is a breach of those regulations in relation to the provision or the failure to insist upon the provision of table service exclusively. That is something for which Mr. Melody has already been penalised quite heavily. It is something that he accepts which shouldn't have happened, It is something which he has explained how it came about. And in my respectful submission to you, it would be completely disproportionate to revoke somebody's license, effectively revoke the premises license, destroy Mr. Melody's living of the last 30 odd years for something such as that. I mean, it rather pales into insignificance, as I'm sure we would all know, to the sort of things that have been in the media most recently. And in my respectful submission, once the committee can see that that is all you are actually being asked to consider, then that would be, in my respectful submission, a completely disproportionate response to what is before you. They're my submissions.
Thank you. Okay, any clarification on what's been said?
I have a clarification from Mr. Gardner, actually, in the light of that, which was that Mr. Gardner mentioned that the coronavirus restrictions at that point meant that SEV licenses were in effect suspended for that period. Is that right? So any kind of operation which assumes that an SEV license is in place would have been in breach of the coronavirus rules. Is that correct?
That is correct, yeah.
Chair, can I just interpose to inquire what is the regulation that Mr. Gardner is relying upon, because I can't find one.
I don't. Mr. Gardner, do you want to expand on that or not?
I think I'm not able to give you the exact sort of legislation on this one, the name of the legislation, but it was widely known, and it was extremely widely known. In fact, virtually every other premises was trading in that way, and unless they'd spotted a sort of loophole in the law that Mr. Forbes is now alleging, I find that surprising indeed. Maybe I call perhaps Mr. Chewett might be able to assist me in this. I'm not sure, maybe not, or maybe Amanda from the legal section. But I would say that in fact that these regulations were in place and had been for some time, and there was some difficulty because of course they were being renewed every 3 weeks. There were levels. There was a lot of confusion around in some aspects of them. But the centrality of it was that at that point in time, these regulations were in place. Table service was necessitated. Track and trace required sort of people giving names. I think we all remember that as we went into venues. And I believe that faced residents, bar people who visited bars, and the staff had to take precautions. The customers themselves had to remain seated and receive table service. This was universally known and universally applied and universally obeyed, except in this instance.
Thank you, Mr. Gardner. Amanda, you wanted? I think we've moved into sort of discussion and points through the chair now.
Yes, I was just going to confirm, yes, it is correct that the points that Mr. Gardner is saying were widely known. They may or may not have been itemised in the regulations, but there would have been some sort of guidance notes separate to it, because all hospitality and venues had to comply with it at the time. So it's not something that's completely new or something that's separate only for your premises. It is something that all premises had to comply with if they wanted to operate or continue operating throughout the coronavirus period. So I would say that is correct what Mr. Gardner is saying. I apologise, we don't have the procedure note to hand. But it is clear that, and it was widely publicised both in the news and everywhere purposely, so that all venue holders, all premises holders would be aware that they needed to put those precautions into place or to seek the necessary guidance from the licensing authority. Again, Mr. Gardner, maybe you can confirm that if, for example, in this case, if the license holder didn't know what was required, he could have contacted the licensing authority for some guidance as well?
Of course, yeah, we were very active in terms of informing and giving guidance to licensing authorities. But I have to say, we were never approached by Mr. Melody on this point, I don't think.
And I think the police also were working jointly with the licensing authority to make sure all of these were in place. And they also do enforcement action themselves, where they identify when these requirements were not being complied with. So it isn't unusual that these, if they were found not to be complied with, that they will be brought forward as issues on the licence.
Am I right in assuming that the other two services with licensing in Hackney were at that time closed? Or did you do any visits the other ones?
No, we didn't visit those particular premises. However, we did visit many other premises which were observing the regulations. The other two which had sexual entertainment licenses, we did not enter. No, okay. The other three premises.
No, but anyway, okay, cool. Anybody else have anything they want to say?
I would like to come back eventually, but I will wait my turn.
Councillor Root.
It's another point of clarification, really. Mr. Forbes seems to be telling us that if the licensing officer's objections are around the fact that the SEV license was not in place at the time, when actually it was, that even if the premise was breaking the terms of the SEV license, we would not be able to revoke it. That seems to me pretty extraordinary. But I wonder if Mr. Gardner or if Amanda could
the matter before you, I think, and the legal advisor Amanda will explain this, I think, is just the premises license in terms of its provision of alcohol and nothing else.
yes, we're not talking about revoking the actual sexual entertainment license. It's only the alcohol license that we're actually considering, and whether or not that should be revoked. So, and also just for clarification for the premises license holder, we're only considering the review of the license today, of the premises license for alcohol. We're not considering the renewal of the license today. That's going to be dealt with on another occasion.
Okay, thank you.
Okay, so it comes down ultimately to our view of the breaches of the SEV license as being breaches of the COVID regulations, ultimately, and how seriously we take that, which in the context of how we apply SEV licenses within Hackney, I think we do take quite considerably seriously. Okay, if we're finished, I'll go back over to Mr. Forbes, please, if you want to answer. You said you wanted to come back.
Yes, well, I do, Madam Chair. Madam Chair, these are quasi-judicial proceedings, and Mr. Melody is entitled, as I'm sure everyone would accept, to a fair hearing.
Yeah.
The hearing which he receives must be based upon the legal requirements, but it must be based upon the paperwork before the committee. If the committee were to stray from that, then of course it is open to Mr. Melody to seek redress for that in the courts, and I would have to advise him about that if I took the view that that is what had happened. Now, what you have before you is an allegation of breaches of the health protection coronavirus regulations. I have said all the way through that the failure to insist upon table service for the consumption of food and drink purchased in the premises is a clear breach, and that is something which has been dealt with. It is something which you can obviously take into account in considering this application, but that is all. It's all very well for Mr. Gardner to talk about loopholes. It doesn't seem to me to be a loophole. The regulations say what they say. I've invited Mr. Gardner, since he seems to allege that these various other matters are breach of the regulations, to draw my attention to them, but he says he's unable to do that. It may be that he's unable to do that because there aren't any, because I certainly couldn't find any. And that's the real point that I'm making. And that is, in my submission, is what the committee is restricted to considering.
Absolutely.
And if it were, it's all very well saying that other things are widely known and all the rest of it. That's not a breach of the coronavirus regulations. It is a matter of law. And if you look at the notice which Mr. Melody was given, informing him of the fixed penalty, which I have, is that it refers specifically to table service and nothing else. And the reason it couldn't refer to anything else is because there isn't anything else.
If I could just, sorry,
I haven't finished
through the chair, sorry.
Mr. Gardner, I'd really be grateful. I didn't interrupt you at all, and I'd be grateful if you let me finish. So, in consequence, in my submission, the committee is confined to looking at what Mr. Gardner has put forward on the papers, because that's what Mr. Melody has come here to answer, which is an allegation of breach of the coronavirus regulations. That is the only one that I can find, and neither Mr. Gardner or anybody else has been able to refer me to anything beyond that. So that is what I would ask the committee to consider and to confine itself to that. And in my submission, to revoke a premises license of long standing on that basis alone, when it has already been penalised in this way, would be disproportionate. They're my submissions to you.
Right, thank you. I believe I had summed that up myself before you spoke, but fair enough. I believe I'd narrowed it down to whether the committee took the view that breaches of the SEV licence, as described, were also breaches of quite serious breaches of the COVID regulations, not specific regulations, but as you say, this is a quasi-judicial hearing, and we also talk about common sense in these committees and what the average person would see as reasonable. So I think that will also apply here in terms of our interpretation of the COVID regulations and people's contact with each other. David Tuitt, I think you wanted to make a point.
It's just to clarify the regulations that we're talking about. It was the Health Protection Coronavirus Restrictions Steps England Regulations 2021. So if you can cast your minds back to February, when the government announced a roadmap out of lockdown, and that roadmap had 4 steps to it, steps 1 to 4. Step 1 was applied mainly to education. It was until step 2 that impacted hospitality, where hospitality venues were allowed to serve people outdoors at step 2, and that was not before the 12th of April, and then not before the 17th of May. Hospitality venues could hold people indoors, and it was after that step 4 was proposed not to be 24th of June. Would remember that the original plan was for, I believe, not before the 24th of June, a relaxation of all of the COVID restrictions, but that was the delay. That was what's been talked about in regards to this particular matter. That step 4 was delayed until the 19th of July. And so at the time of the visits made to Yodax, we were still in step 3. And in step 3, sexual entertainment venues were considered a restricted business, along with certain other types of business, hospitality businesses like nightclubs. That's the regulation that we're alleging was breached.
So there is a clear regulation as well as some.
Well, Madam Chair, as I keep saying, I can't find it. If anybody can draw my attention to it, I shall withdraw what I said, but I can't find it. I have in front of me the relevant regulations. It is Schedule 3, Part 2, Regulation 7, if anyone's interested.
Okay. Okay.
Through the chair, what Mr. Tewett has just said about the regulations, the subsequent regulations that were with the roadmap, is that not acceptable? No?
Well, there seems to be, I mean, David Tewett has quoted us that SEVs were considered a restricted business. Mr. Forbes is disputing that. So
he's saying that he doesn't accept this regulation that Mr. Tewett's saying.
He is saying that he doesn't accept that SEVs were considered a restricted business, I believe. Is that what you're saying, Mr. Forbes? Under the COVID regulations?
Madam Chair, people can talk about all of these things. All I'm asking them to do is to relate it to the ground which is before you, which is a breach of those specific regulations. If anyone is saying that these other extraneous matters are in breach of a regulation, I would simply invite them to point me to it. I can't find it.
I mean, the other thing you said, forgive me, Mr. Forbes, you also said that what occurred may or may not be breaches of the SEV license, which implied that you accepted that they might indeed have been breaches of the SEV license. So it puts the committee in this difficult position where we're looking at behaviours that were not even covered by the SEV license. So I think the committee will therefore make its decision based on some sort of common sense interpretation of the COVID regulations at the time, and that's the best that we can do. If you have any serious argument against that, then I'll hear it quickly.
Yeah, I do. The SEV license is not before you.
I know that. I specifically agreed with you about that.
No, perhaps I can just finish what I was saying. The SEV license is not before you. It may be brought before a committee on some future occasion, and that's when these matters can be considered.
But you've misunderstood me. You've misunderstood me. You raised it in saying that these activities may or may not be breaches, which implied that you were aware there was a possibility that they were breaches. And that puts us in a position where we are looking at the COVID regulations in terms of both legitimate SEV license activity and illegitimate several license activity in this case. So those, I'm just telling you now, those will be matters that we will be looking at, and I think we're entitled to do so.
Well, Madam, I express my dissent to that, but obviously you will make whatever decision you think is right.
Absolutely fine, thank you. Okay, I think we probably heard. Have I got questions? Sorry, Robert. Gardner.
Just one final point. I would point to the to what the licensee's representative said in his argument against this, his written argument, and he states it is accepted that the operation of the premises on the relevant dates were not in compliance with the regulations as to recording of customer details, wearing of face masks, and the restriction to table services. So I think at that point, Mr. Forbes has obviously done further research that he wants to recant that particular statement, I would imagine. I don't know.
Yes, exactly right.
But it seems to me that that I think, and also the fact that, of course, Mr. Melody did in fact pay the fixed penalty notice for the breach of the said regulations, and I think it was more that was listed in there was probably more than just the aspects of table service. So I believe that this is a technical argument.
Okay.
Well, it's not what's on it's what's on the document in front of me. It only refers to table service, nothing else.
Okay. Right. Are we, as a committee, do we need to have any more information?
Can I, sorry, just to clarify, the £1,000 fine that Mr. Melody's already paid, did that relate only to the table service breach or to other breaches of the coronavirus regulations?
Madam Chair, I have the document in front of me. That is specifically what it says and nothing else.
It says that it was breaches of the table license, the table service.
Yes, I can read it to you if you'd like to hear it.
I think that might be useful, because one of the reasons I think it might be useful is because there are several breaches of the coronavirus regulations here. And if you're asking us to be proportionate in what we are looking at, we need to know exactly what that £1,000 fine was levied for.
Yeah.
And if there are breaches which were not covered by that, then we would have to take those into consideration, it seems to me.
Yes. What it says is this: grounds for imposing the penalty in relation to a breach of a Step 3 restriction imposed by Regulation 7 and Part 2 of Schedule 3, Paragraph 7, Subparagraph 1, and that's what I've already referred to. It then goes on to say, failed without reason of excuse to cease carrying on the business of providing the service listed in Part 2 of Schedule 3, Paragraph 7.1 and 9.1. And the particulars of the offence: on the 9th of July 2021, at 22:30 hours at the Old Hacks, 69 Hackney Road, a business under the control of Thomas J. Melody, authorised officers of the London Borough of Hackney witnessed drink being served to, without reasonable excuse, and consumed by customers not seated at tables, including people standing at the bar and drinking. These activities are not permitted in restricted premises and are in contravention of the above cited regulations. Food and drink in pubs and clubs must only be ordered and consumed by customers seated at tables. That is all it says, and indeed that is all I can find in the regulations that could conceivably have been breached, and that is what I accept, and that is why he paid the £1,000 fixed penalty.
Could I ask Mr. Forbes, I mean, what you've quoted there is something which clearly relates to some quite complex set of regulations with various different clauses, sub-clauses, etc., etc. It does seem to me pretty extraordinary that within those you weren't able to find anything relating to any of the other things that you've talked about, if you've looked through the detail of all of those sub-clauses and different paragraphs.
Madam Chair, I have looked through all of them, and I would not have said what I did unless I was satisfied that my search had been thorough and comprehensive. And it's not for me, really, to find the regulations which Mr. Gardner is alleging were breached. If Mr. Gardner wants to allege that, then surely he should have come armed with the information to place before the committee. If he's not done so, it's very difficult to prove a negative. I've done the best that I can.
Fine, thank you. I'll just point out also to the committee that it isn't unusual for licensed premises to face, as it were, a double jeopardy. The offence under the criminal law that occurred, but our business is to look at that in terms of the management of the premises and the license and the responsibilities of the licensee. And while that may seem, there's nothing untoward or double penalty about this. They're completely separate things. This is not a penalty. This is about the licensing authority taking responsibility for the good management of premises within Hackney. So this isn't we can and have reviewed premises on the basis of failure to adhere to COVID regulations, because it has represented serious failures in the management of the licensed premises. Okay, Amanda.
Yes, so through the chair, can we just clarify then that apart from the table service, the representation made by solicitor saying that his client accepted the breaches, is that still standing? Is he still maintaining that, or is that now withdrawn from his representation?
He accepts the breach in relation to table service. It doesn't seem to me, on further research, that any of the other matters referred to are actually prohibited by the regulations, unless somebody can point to another regulation, which I haven't found.
Okay. But we are talking here about good management of premises and what the licensing authority and everybody else, apart from this premises, took to be good practice at the time, given that they were responding to a pandemic. And in terms of the committee here, we're not lawyers. We will look at this from the point of view of what seems reasonable in the circumstances, both from the point of view of your client and from the point of view of our licensing authority and from the point of view of, as it were, our residents. Okay, Penny. Councillor Root.
It's really just I suppose a question to David in a way, because I do remember very clearly when we were at step 3, and there was a lot of excitement about when we would get to step 4, partly because of the impact on young people. And I have a daughter who's of kind of club going age, and she and her friends were all very interested in when step 4 was going to come into play so that she could go to clubs. I suppose my question is, it hadn't occurred to me about SEVs at the time, and there was no publicity about SEVs. But is it standard practice that SEVs are kind of put together with nightclubs in this way? Would it have been? I suppose what I'm asking is, would it have been odd for Mr. Melody to know that clubbing wasn't allowed, which everybody knew? And to not realise that meant that SEV activity wasn't allowed as well.
Sorry, Penny, Councillor Rich, are you asking?
I suppose what I'm saying is it standard practice that nightclubs and SEVs are kind of put together in this kind of way? Well,
we heard from Mr. Tuitt that, in his view, SEVs are considered a restricted business, and he believes the regulations make that clear. We understand that from David Forbes that he disagrees with that. So we have to make a decision about that, and that's why I've tried to clarify in terms of the different things that we look at in terms of the licensing and good management. David Tuitt, you want to comment?
Shall I just Chair, talk about those regulations again? So it's the Health Protection Coronavirus Restrictions Steps England Regulations 2021. Those were what were announced by the government in February, and then began to come into effect from March onwards, with steps 1, steps 2, 3 to 4, 4 being the end of the regulations, the end of the restrictions. So under those regulations, Schedule 3 sets out step 3. Part 2 of that is closure of and restriction on businesses. Paragraph 6 is requirement to close certain businesses. It talks about the businesses that have to be closed. A person responsible for carrying on a restricted business or restricted service must cease to carry on that business or provide that service. Then it sets out in paragraph 9 what those types of business are. It lists a number of businesses: nightclubs, dance halls, discotheques, other venues which operate late at night, but it also includes a subsection E, sexual entertainment venues, and that was under step 3. So sexual entertainment venues were a restricted business under step 3.
Thank you. The reason I asked it, and I'm sorry for the confusion by referring to Mr. Tuitt as David when I should have called him Mr. Tuitt, because we've got 2 Davids. Apologies for that. The reason I wanted to clarify that is because in terms of the good management of the premise, it seems to me that there really was no scope for any confusion then. Whereas, you know, if what you've just read out weren't explicit and were implicit, then perhaps Mr. Melody might have had some reason for not understanding. But as it is, it seems to me absolutely explicit that his venue was covered by step 3.
Yeah, that's very helpful. Thank you, Councillor Root, for raising that, and thank you, David Tuitt, for finding that for us. Amanda, do you want to?
Yes, through the chair, does the representative for the licence holder want to have a moment to check those regulations, or to be satisfied that he's happy with that, or is he happy with what Mr. Tuitt said?
Well, I don't dispute anything that Mr. Tuitt has said, but it doesn't really deal with the point that I'm raising, with all due respect. The point that I'm raising is that you have before you an allegation of a breach of the health protection coronavirus regulations. The only regulation that I can see that has been breached is that relating to table service of food and drink, and none of these other things fall within that definition. That is what is before you, and that is what you have to consider. Just that and nothing else in my submission.
Except that we just heard that the served part of the business should not have been operating.
Well, that is a matter which if and when the committee decides to consider the application for renewal of the SEV license, that is a matter which would no doubt be debated, but it's not before you today, is the point I'm making.
The point is that it shouldn't have been open under COVID regulations.
What, the premises completely?
The
Yes.
SEV part of it, yes.
Well,
that's what we just ascertained.
But that's not what's been alleged, is what I'm saying.
Well, actually, it is alleged that. I think it is specifically in Mr. Gardner's statement, actually.
I think it is, yeah, I agree.
What you look, it specifically is alleged.
I can't find a regulation which...
But let's not go, we've just gone through this for you, and we've asked you... Sorry, forgive me, but we have asked you if you wanted time to check the regulations.
No, I don't.
Our representative has checked the regulations, and he read it out to us. Okay, I'm drawing this now to a close because it's not going anywhere. So it's a circular argument.
I'm entirely
unless you want to change your mind and have time to look at the regulations, but I think we made that offer and you didn't. So
no, I don't, because I've already made a thorough research. I'm totally satisfied with what I said.
Okay, that's fine. Amanda, did you want to say? You wanted to say
Yes.
something else before we?
Yes, just to finally say that whilst I note what Mr. Forbes is saying, that he's only going according to what's on the paperwork, but members are entitled to consider the legislation that's in force. And the coronavirus regulations is obviously a unique set of regulations which came into force for the health and safety of the members of the public. And that's what we're talking about, the health and safety of members of the public, and the fact that the sexual entertainment part of the premises was not supposed to be open. So even though the actual legislation is not probably specified on Mr. Gardner's paper, statement, we are allowed to take it into consideration because it was in force at the time, and would be considered, even, for example, if the police were bringing this application, they would refer to those regulations as well. So members are entitled to consider that.
Yeah. Okay. Very good. Okay, I think I'm going to ask if people want to sum up. without bringing in any new information. Mr. Gardner, do you wish to have a final statement?
I have nothing further to add, Chair.
We'll just check with you that you are still asking for a revocation. There isn't, I mean, the premises hasn't put forward any suggestions, so I'm...
Indeed, I'm still going ahead with the revocation. I have not heard anything from the other side that would make me think otherwise.
Okay, thank you. Mr. Forbes, would you like to make a final?
Madam Chair, I've made my final submission at least half a dozen times. I don't propose to bore you by doing it again.
Okay, thank you for that. In that case, I'll ask everybody now. Thank you very much. We've heard enough, and we'll make our decision, and you will be able to get the decision informally from licensing, I believe, tomorrow. Is that right? Yes, and then the formal decision will come through on email within 5 working days. Okay.
So, Madam Chair, does that mean our involvement tonight comes to an end at this point?
Yes. What we do now is, because we are online, we ask, we can't withdraw and come back. So what we ask you to do is you leave this meeting, and then we stay on the call. We stop recording and we make our decision jointly now.
Very good. And so the decision will be available tomorrow?
I believe the decision will be available.
A summary of the decision as to whether or not the licence has been revoked or not, or whatever decision the members decide, that will be available in summary form tomorrow from the licensing authority, and then the full decision will be out in hopefully 5 working days.
Yes, well, you have my email address. I'd be grateful if somebody could email me once that decision is known.
Okay, I will ask the licensing officer to email you with the summary of the decision tomorrow. Thank you.
Okay.
Very good.
Right. Thanks very much. Thank you, everybody.
Good evening.
Good night.
Thank you. Good night.
Good night.
Thank you.